for entered in the record of this meeting.
Without objection, so ordered.
Thank you.
Next is Senator Specter, who's former chairman of this committee and certainly one of the most knowledgeable lawyers in the Senate. Senator Specter.
Thank you, Mr. Chairman. I will vote to confirm Judge Sotomayor. She brought to the confirmation proceedings an extraordinary record, none better on the 11 I've participated in, or none better than any I've reviewed. Pretty tough to be summa cum laude at Princeton. Pretty tough to make the Yale Law School admission. Even tougher to become a member of the Yale Law Review. Then an outstanding prosecutor. The Dean of American Prosecutors, D.A. Morgenthau, came to testify about how good she was. Extraordinary record professionally in private practice. Distinguished record on the bench. And those qualifications add up to about an A+. The criticisms made of her on the wise Latino woman, I thought were not only ill-founded, but I appreciated the comment. When you consider that women were not given the right to vote until 1920, and when you consider, may the record show a smile from Senator Feinstein, when you consider that there is still a tremendous glass ceiling, when you consider Lilly Ledbetter, it go on and on and on about the appropriateness of a woman standing up for women. If a woman didn't stand up for women, I wouldn't think much of her. And Senator Durbin had a poetic sequence of questions about women's insights that are different from men's insights. And believe me, as a senator who came here with one woman senator, Senator Kassenbaum, and the second was added, Senator Paula Hawkins, it's a very different place today with 17 women, and a much better place. And there was a book out, 9 Women and Growing, and now it's 17 and will grow even more to the benefit of this institution. And when she refers to being a Latino, that's a little ethnic pride. I think that's a pretty healthy thing, to have a little ethnic pride. So I not only found, I didn't find fault with a wise Latino woman, I thought it was commendable. And then the business of empathy. There is no doubt about the history of the Constitution in our country responding to empathy. Holmes, the life of the law is experience, not logic. Cardozo and Palco, shifting values. Plessy versus Ferguson, 1896, separate but equal. Borum versus Board of Education, shifting values all the time, and that's what makes this country so great. The one grave concern or the one regret I have about Judge Sotomayor's testimony was her extreme caution, just extreme caution. And I don't know if it was her decision or if that attitude was promoted by her advisors. But there's no doubt, well publicized, that in the White House there are so-called murder boards where the nominees are prepared, and that's fine. They ought to be prepared. But the hearings did not produce a whole lot about what Judge Sotomayor's philosophy is or her ideology, to pick a couple of words, or her approach. If you see me dab at my eyes, I'm not sad. It's chemotherapy, and I've made the Kleenex industry wealthy. But I'm glad to say that I'm fit as a fiddle, ready for re-election. I'm not not infirm in any way. Just a little consequence of chemotherapy. But I make that comment because people wonder about it. There has grown up a myth about Judge Bork's confirmation hearing. And the myth is that he was borked. They've turned it into a verb, or maybe it's a participle. I'm not sure what borked is. Except I know it's not true. Judge Bork answered a great many questions because of his writings and because of his background. He believed in original intent. And he did not believe that the Equal Protection Clause applied beyond, as he put it, race and ethnicity. Did not apply to women, did not apply to disabled, did not apply to a litany of Supreme Court decisions which have expanded equal protection to the benefit of this country. He did not believe in due process of law. He did not believe that it was appropriate to incorporate the 10 amendments, or a number of the 10 amendments, to apply to the states because of the breadth of the due process clause. When I asked him how he would have desegregated the District of Columbia schools in a context where equal protection applied only to states, Brown versus Board of Education, there was a companion case, Bowling versus Sharp, for the D.C. schools, and the Supreme Court had decided that the due process clause of the 14th Amendment incorporated equal protection, which then made it apply to D.C. When I asked him how he would desegregate the D.C. schools, you know what his answer was? I want a recess. And he came back and he talked about freedom of association. So Judge Bork wrote about Hess versus Indiana as an obscenity case, and he testified about it as a free speech case. Judge Bork didn't know his own record. And it would be my hope that we could structure some rules. After Justice Scalia answered virtually no questions, strike virtually. After Justice Scalia answered no questions, Senator DeConcini and I considered having a resolution in the Senate to set a standard. Well, you can't set a standard for senators on questions, and you can't set a standard for nominees. They answer questions and they take their chances. If a nominee were to be rejected for not answering questions, it might set a tone, but that's not going to happen. When I asked Judge Sotomayor if she agreed with Chief Justice Roberts that the Supreme Court could take more cases, it seemed to me like that was as soft a softball as you could find. After I studied the statistics, the Supreme Court decided 451 cases in 1886. A century later, in 1985, 161 written opinions, and in the 2007 term, 67 written opinions. It's time we televised the Supreme Court so the American people could see what they don't do. What they don't do on deciding circuit splits. But I won't elaborate upon that point now because I've done that in the past. On Roe versus Wade, there were a lot of people in America looking for a little assurance on Roe versus Wade. Well, I'm pretty confident how Judge Sotomayor will decide the issue of a woman's right to choose, but not because of anything she testified to. And you don't have to make Casey a super precedent, but you could say that when the court has had 38 occasions to reverse Roe and hasn't done so, that that's a weighty factor. And saying it's a weighty factor is well within the range of the generalizations on stare decisis. And I could enumerate quite a number of other questions I asked her. And asking a nominee questions is hard. We all have a very limited amount of time. And I didn't like interrupting her a little. There's been some commentary on that. A couple of people have said that it was not inappropriate since she wasn't answering the questions. And a lot of the questions were being asked to ask the questions. I think these nomination proceedings are really very good for the country. Very important to educate the country and remind the Supreme Court that when they have standards like proportionate and what's the other half of proportionate? Proportionate and whatever, that nobody can't remember what proportionate and congruent. Thank you, team. Did you say those sessions? I didn't hear you. I thought of it too, but thank you.
You taught me that phrase.
And when you have Chief Justice Roberts saying that he's not going to disagree with Congress on finding the facts, and then you have the voting rights case, and all indications are he does, those are matters to be pointed out. Just one other comment about the firefighters case. Judge Sotomayor's opponents thought they had her on that, but the critical question was, did the firefighters think she did anything but act in good faith? And both of them said they did not. So while there are concerns about the way she's answered the questions, we've got a lot to judge her on aside from her testimony. The 17 years on the bench tell us enough to know that she is well qualified for the job. And it is my hope, and I expressed it to her and got no response again, that she would run a hot advocacy role in the conference room, like she's reputed to have run a hot court, and that her litigator background would lead her to challenge other justices in the conference room, because there is no question about all of the platitudes we say about interpreting the Constitution and statutes. The Supreme Court makes a lot of laws. They make a lot of laws. And we have to trust their values, that they're within the mainstream and within the bounds of what this country has stood for and what it should stand for in the future. I vote aye. Thank you, Mr. Chairman.
Thank you very much. And Senator Franken.
Thank you. Thank you, Mr. Chairman, and I want to join my colleagues in thanking you and the ranking member in the way you've conducted this hearing. I'm going to speak more about this on the Senate floor, so I'll keep my remarks brief. The nomination of Judge Sonia Sotomayor comes at a critical moment for the Supreme Court. The current Supreme Court has consistently struck down and questioned long-standing critical protections for Americans. And I'm talking about individual rights, individual protections, individual liberties. I think some of my colleagues said this best. As Senator Feinstein mentioned, this Supreme Court ended a 30-year precedent stating that any measure regulating a woman's right to choose must always protect the health of the woman. As Senator Cardin and Senator Specter said, this Supreme Court came close to overturning critical portions of the Voting Rights Act. The court did this despite the express powers that Congress was granted under the 15th Amendment to enact this law, and despite the fact that this body has reauthorized these measures 4 times, most recently just a few years ago by a vote of 98-0. As Senator Cole and Senator Kaufman mentioned, the Supreme Court reversed a 100-year ban on price fixing under the Sherman Act. This shifts the burden to consumers and small businesses to show that price fixing hurts them. Today, thanks to this ruling, a small business owner can't just show that price fixing has occurred. He or she has to prove through a complex economic analysis that it will hurt competition. This is the same Supreme Court that said that older workers don't have the same rights in the workplace as minorities or women. that made it harder to sue for age discrimination in the workplace. It is now harder, if not practically impossible, for an older worker to sue an employer who fired him or her because her pension was about to increase dramatically in value. This is the same Supreme Court that stands poised to overturn another 100-year principle in place since the Tillman Act of 1907, that corporations should not be spending money in our election campaigns, not in donations, not in ads, not in anything. The court upheld this principle in 2003 when it upheld McCain-Feingold. And yet the Supreme Court has decided to reconsider the constitutionality of a provision it upheld just 6 years ago. This is judicial activism. This is a court that is willing to reverse itself to limit the rights of individual Americans. This is a court that is more than willing to overturn Congress to achieve its own agenda of what is right. And in this context, in these times, a vote for Judge Sotomayor is a vote against judicial activism. It's true, as a lawyer, Judge Sotomayor was an advocate for the Latino community. She was a dedicated advocate. But as my friend and colleague Senator Graham noted on the floor of the Senate, Judge Sotomayor's record, her record, is not that of a judicial activist or that of an advocate for any individual or any interest group. Over 17 years and in 3,000 cases, Judge Sotomayor has proven herself to be an objective, impartial jurist, a fair judge. A fair judge. In her life, Judge Sotomayor has overcome a lot, more than most people who have accomplished as much as she has. But her record alone is reason enough to vote for her. I am proud to be her supporter. Thank you, Mr. Chairman.
Thank you. I will put in the record many letters of endorsement for Judge Sotomayor we've received from law enforcement groups, current and former Democratic and Republican officials, civil rights groups, Americans of all backgrounds, including 32 letters received since the hearing, and ask consent that they be in record. Without objection, they will be. I do want to note, one, I appreciate the comments made by senators on both sides of the aisle complimenting Senator Sessions and myself for holding this hearing. Senator Sessions and I had a lot of discussions prior to the hearing. As I told him, I was going to make sure everybody could ask whatever question they want, give as much time as they want, whether repetitious or not, and I think we did that. What we're going to do is we're going to have a roll call vote on this in just a moment. Then, after that, please ask everybody to just stay for another couple of minutes. There will be a motion to take up the 4 other nominees en banc and then have a voice vote on them en banc. But the clerk will call the roll on the nomination of Sonia Sotomayor to be a justice of the U.S. Supreme Court.
Mr. Cole.
Aye.
Mrs. Feinstein.
Aye.
Mr. Feingold.
Aye.
Mr. Schumer.
Aye.
Mr. Durbin. Mr. Cardin. Mr. Whitehouse.
Aye.
Ms. Klobuchar. Mr. Kaufman.
Aye.
Mr. Spector.
Aye.
Mr. Franken.
Aye.
Mr. Sessions.
No.
Mr. Hack.
No.
Mr. Grassley.
No.
Mr. Kyle.
No by proxy.
Mr. Graham.
Aye.
Mr. Cornyn.
No by proxy.
Mr. Coburn.
No by proxy.
Mr. Chairman.
Aye.
Mr. Chairman, the votes are 13 yeas, 6 nays.
The nominee has been approved by the committee. The name will be sent to the full Senate for its action. I ask unanimous consent that Thomas McClellan, Alejandro Mayorkas, Christopher Schroeder, and Cranston Mitchell, those 4 nominees, be considered en banc. Without objection, they will be considered en bloc. Those in favor of those 4 nominees signify by saying aye. Aye. Opposed? The ayes appear to have it, and I would note that we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 15 senators in the room.
Mr. Chairman,
yes.
I think there's some concerns about some of the nominees, but I think our members are committed to letting it go forward. So thank you.
I appreciate that. We stand in recess.